Hi, it's Elizabeth Willits here from Investing in Women. Thank you so much for joining us today for our Facebook and LinkedIn Live. I'm delighted because today I'm being joined by Tom Stenner-Evans, who is an employment solicitor with Thrive Law. I'm going to be talking all about redundancy today. Is it just business or is it ever personal? I'm sure we're going to have a lively discussion with Tom, as we always do. If you've got any questions about redundancy, please pop them in the comments as we go. If you've got any experiences you're happy to share, again, please feel free to pop them in the comments. Do let us know if you can hear us all okay. Give us a like or an emoji, that would be brilliant. But it's Elizabeth Willits here from Investing in Women. I'm with Tom Stenner-Evans from Thrive Law. He's an employment solicitor with Thrive Law, talking all about redundancy today. So thank you so much, Tom, for joining us.
Welcome. How are you, Liz?
Again.
Yeah, nice to see you again.
I'm really excited to get chatting with you today about redundancy. So before we start, do you want to give people a bit of an overview as to who you are and what you do with Thrive Law?
Yeah, of course. Yeah. So thank you again for having me. Nice to see you again. I'm a partner at Thrive Law. We're a boutique employment law, HR, D&I, mental health and wellbeing firm. So we cover the full spectrum of sort of people matters, I suppose. Headquartered in Leeds, with a presence in the Southwest and in London as well. We try and do it a bit differently. We advise on the law, but we try to see it a little bit more holistically and a bit more humanly, I suppose, than most lawyers. Which is why I think this is a particularly interesting topic. It's something that quite a lot of people have probably got some experience of it, either their own or a family member or a close friend has been through redundancy. It's a very stressful time. So just thought it'd be quite a good opportunity to talk about it from a legal perspective, but also from a kind of best practice viewpoint as well.
Yeah, brilliant. So is a person made redundant or is a role made redundant?
That's one of the first questions that people always ask. So technically, it's the job that is made redundant, as opposed to the person. So a person is not made redundant because they are not up to standard or anything like that. It's the job that they fill, which might be disappearing. Now, the obvious knock-on effect of that is that the post holder, it feels the impact of it. So in theory, it shouldn't be personal. It should be that there isn't a need for a particular job, or if a particular workplace is closing down, that job disappears, and the person who happens to be in that job is therefore made redundant. But it's quite difficult to differentiate the two if you're involved in it, isn't it? Because you're seeing your job disappearing and you're going to feel the impact of that on your rent or your mortgage or your family.
Mm-hmm. Absolutely. And I mean, from my personal experience, when I was made redundant, it actually did feel quite personal because I was put in a pool with, colleagues and friends, and then we were assessed against each other, and they make a selection on individuals, really, on who's going to stay and who's going to go. So it does, from an individual perspective, feel quite personal.
That's a really good point, because you'll sometimes get scenarios where there's a pool of people affected. So you might have had a dip in sales, and your sales team of 10 people, you just can't sustain perhaps more than 5 for the workload. So at that point, yes, okay, 5 jobs are disappearing, but the employer is going to conduct a selection exercise to identify the 5 strongest people. So it's very difficult to get away from the fact that at that stage there is an element of I suppose, sort of it being personal, because they want to retain the people who are most valuable to the business. Now, how you determine value is quite subjective, but either way, there are going to be people who are told in no uncertain terms that you are not as useful to us going forward as some of your colleagues, your peers. So, and in those circumstances, which is something I'm sure that we'll touch upon, it's all the more important to stress why this is sort of business related and it isn't personal. But very difficult in those situations not to take it personally if you're being scored lower than someone else, and then being told that you're essentially surplus to requirements. Very, very difficult, not to find that hard.
So if you're an employer watching this and you have to make a pool of people redundant now or in the future, how can you go through a selection process and make it fair and make it actually feel less personal, and therefore reduce your risk of being accused of discrimination or other things afterwards?
So the key thing, and this is a sort of message that we always preach in employment law and HR, and if anyone's listening here has an HR background, they'll be able to relate to this, is the level of communication that is sent out, that is prepared, is nearly always inadequate. Mm-hmm. If you're creating a selection pool, you should be communicating to those people how you've come about creating that pool. What's your thought process in putting those 10 people in the pool? Why have you not included people from another sales division? Or why have you not included people who work in the office 5 miles away? And why have you limited it to these people and not so-and-so else? Like, that level of communication is a starting point to say, it's only sales of this particular product, and you're the people who focus on this product. That's why you're affected and these people aren't. Like, try to anticipate what question you would ask if you were in their shoes and provide the answers to those questions as early on in the process as possible. Most people, I think, respond well if they understand a decision. You know, it's just a fact that sometimes businesses might close down sites, they might struggle financially, and these things need to be, made. But if you could do it in a way that is open and transparent and communicative, you make it less stressful for people because they understand. Quite a lot of challenge comes from a lack of understanding, and therefore an assumption that there must be something untoward going on. That's often not the case. Yeah, sometimes it is. That's often not the case. Mm-hmm. So just give time to your selection pool. If you're the employer, think about like what potential pools, plural, there might be, how you could construct it, what's fairest, what works for the business. That is a valid consideration as well. And then communicate that as much as you can.
So I'm sure we've all heard of examples of people where employers have used redundancy as an excuse to maybe fire somebody, and for whatever, a whole host of reasons. So what, as an employer, what are your reasons for redundancy? Is there any sort of legal requirements? Or
yeah, there is. Yeah. So it's in section 139 something or other, I think, of the Employment Rights Act 1996. And there are essentially 3 circumstances where it's a business closure. That's pretty self-explanatory. Like, you are shutting down the business. There's a workplace closure, so perhaps you're shutting down a particular site, or there's a reduction for the requirement of work of a particular kind. That is what I would say probably 9/10 of redundancies are. It's, we don't need as much person power to do this work. We've had a drop in sales, we've lost a big client, we've got too many people, too much resource to carry out the work we need. Therefore, we have to sort of scale back. That's what nearly all redundancies that I've come across tend to be. It's not really contentious. If you're shutting a business down, you say to everyone, I'm sorry, we're liquidating the business, it's going under, so you're all redundant. Yeah, it's horrible news to get, but it's less likely to be contentious because it's so clear cut. It's the grey areas where there's an element of subjectivity on the part of the employer that is making a decision about what they feel they need. That's where you tend to get the challenge. But the employer should start from a position of, what do we need and where's the reduction? And then that should determine who's at risk of redundancy, what selection pool you might need, and then generally what process you would follow. Yeah. And if you communicate that's the starting point. Perhaps some of the best advice that I could give to employers is to front load the time on this. Like, the more you invest in putting together a good proposal document to show to the affected staff, the more they understand things from the outset. If you get off on the wrong foot, it's very difficult to get back on the right one because you've damaged that trust.
Yeah.
Which is obviously far from ideal from a legal risk perspective. But also, if you look at this more holistically, some of these people may not be made redundant, and they work with colleagues who may or may not be affected. People talk, they have friends in work. And the people who survive this process will look to the employer and will judge them on how they've conducted this process. I always say, it's very easy to be a good employer in the best of times when you're handing out bonuses and it's easy to give this and give that and offer this and offer that. The mark of a really good employer is how do you treat people when things aren't going so well? And people will see that. And if their friends and colleagues are treated poorly, your likelihood of holding on to those people, if a good offer comes along from somewhere else, significantly diminishes, because they will have earmarked you as someone who was not perhaps as good an employer as they'd originally thought.
Okay. So we talked about the importance of communication during a consultation period when making something redundant. So what are there any legal requirements, minimum requirements in terms of consultation period? How many times you need to meet somebody? Do you need to give them those scorecards? How transparent should it be?
Well, so to answer that question, yes and no. So there's no requirement for a minimum consultation period if you're dealing with a very small number of redundancies. It's just what's reasonable, and what's reasonable will depend on the circumstances of each case. It will depend on the complexity, the amount of time that's needed, and actually setting a sort of arbitrary timescale can sometimes be quite damaging. The employer might have a redundancy policy which sets a minimum timescale, but that's not that common. When you get to 20 or more proposed redundancies, then you enter what's called collective consultation territory, which suddenly goes from being quite fluid and not that formulaic to being the complete opposite, which is very structured. You have to have elected staff reps, which is either perhaps unions or a staff forum, to consult with them on behalf of the affected individuals. The idea being that you might have 500 proposed redundancies and it would be completely disproportionate to try to consult individually with 500 people. So they have elected reps to represent these people at the first stage of it. And if you fail to comply with that process, then there are quite significant penalties for that. Not just the usual sort of unfair dismissals, but there's actually a standalone claim for failure to inform and consult, which each individual employee can bring. It's usually brought by the trade unions and other reps on their behalf. But that's a sort of punitive award up to, I think, 13 weeks pay per person. So if you've got 500 redundancies, you get this wrong, you could be on the hook for 3 months pay per person at actual rates, which is an enormous amount of money. So there's a sort of financial incentive to get it right at that stage. But for most redundancies where you're dealing with fewer than 20, which is usually the case, it's just about following fair process and sort of allowing time for consultation. So that might be that you start off with a sort of group meeting to tell everyone who's affected, and then you might have a sort of individual process where you sit down and explain to each person why it's their role that's affected. That might get broken up by a scoring process or an application process for redeployment roles. Then you might have some further consultation meetings. So it could be a few weeks, could be slightly longer. But to me, I would say it's about taking the time it needs. And if that takes you a couple of extra weeks or a little bit longer than that, it's time well spent from every perspective. From the employer's viewpoint, you minimize the risk of any legal challenge because people are more likely to get to the end of the process satisfied, if that's perhaps the right word, that they've been treated fairly. Now, they may not like the outcome, but they will have been treated fairly. And from the individual's perspective, it's a mark of an employer who recognizes that just because some of these people might be leaving the organization, that doesn't make them any less valuable, or it doesn't mean that they shouldn't be treated with the same level of respect and compassion as people who are still going to stay within the business.
Yeah.
Because you do see sometimes that there's a sort of, these people are leaving, so they don't deserve our full attention and our full level of kindness. And that's just the wrong way to deal with people anyway. But it's also short-sighted from a business perspective.
Yeah. And can you get people to reapply for their jobs as part of the process?
So, yes. I mean, if you've got sort of a pool of people and if you're restructuring it, say you're taking a team of administrative support people and those roles are being restructured to include different responsibilities or a different focus, then yes, you could put everyone at risk of redundancy and say, right, these are the new roles within our new structure, and we welcome applications from all of you for any of these particular roles. There's this role, this role, and this role. and if they're different, or if they're perhaps more senior, then yes, in those circumstances, you could ask people to apply for those. If it's just a case that you're reducing numbers, then you probably wouldn't do it that way. You probably do it through a sort of competitive exercise, a scoring exercise, or an interview process, something like that. Equally, if there are some other alternative roles within the organisation, so once you've identified that people are confirmed as redundant, you have a duty to consider what's called suitable alternative employment within your organisation, or perhaps even more broadly. So there's case law to say that it could be within the wider group. There's even case law around sort of community schools. So one local authority school potentially having to look more broadly to other schools in the area if they fall under the same LEA. There's much of that, but that's always an interesting point. Then at that stage, if you've got someone who's clearly an obvious fit for another job, you would probably just assimilate them into that job. If there's perhaps a big step up in responsibilities or pay, or it's a different focus, then you might decide to have an application process for that. But those people at risk of redundancy should be given priority for those applications over external candidates or other internal candidates, because the aim here is to try to minimise the numbers of redundancies.
Okay, and can you be accepting voluntary redundancies as well at this point, I'm assuming?
So that's voluntary. You don't have to offer a voluntary redundancy scheme. Sometimes people do. Sometimes they offer it and they enhance it slightly. If they are genuinely happy to do that, if they have the financial means to be able to offer an increased package, that's a good thing to do, because you might get people come forward who are happy to take the package at their stage of their career, or just because the money's worth it, or they're thinking about change anyway. That's always a positive step, because it reduces people having to lose their jobs that don't want to. The employer can reserve the right to reject an application for voluntary redundancy. Mm-hmm. So if you get someone hold their hand up and you're like, oh no, we really need you because you have critical experience in this particular area, so I'm sorry, we can't accept it, that is an option available. I would tend to say to employers, don't offer voluntary unless you're playing it with a very straight bat, which is you don't mind who says yes and you can afford to pay them, whoever it is. If you're trying to use voluntary in a contrived way, and then you have to say no to someone who wants to go, and then you have to make someone redundant who didn't want to go, then you're in a bit of a tricky situation at that stage, legally and from a cultural perspective.
So if you're an employer and you just want to get rid of somebody, what would be your advice to them?
Well, I think the first question is, why do you want to get rid of them? If you want to get rid of them because they're a poor performer, there's a mechanism for that, and that should be addressed through poor performance. If you want to get rid of them because of some act of misconduct, there's a misconduct process for that. If you want to get rid of them because their absence levels are unacceptable, there is a fair process that could be followed for that. Now, those are all how it should be done. You shouldn't use redundancies to get someone out for reasons which are unrelated to a restructuring. Now, does it happen? Yes, it does happen. That's why people lose employment tribunal claims, because the redundancies are probably not genuine, or because they're being used as a quicker way of, say, performance managing someone. That's perhaps the most common example. I think if you're in that situation where you have someone who isn't performing, if there's a genuine need to reduce the number of people in that team, then that poor performer in a scoring exercise is probably going to come out at the bottom anyway. So by nature of that sort of second stage, which becomes a bit more subjective, the outcome is achieved, but in a way that is arguably still fair. Constructing a whole scenario to exit someone on, say, performance grounds is somewhat disingenuous, and I think as well creates significant risk from a sort of workplace engagement perspective, because if people think that you're doing that, and if they conclude that actually someone's been treated unfairly because, let's say, they've been ill, so this is a kind of round the houses way to get them out with minimal risk. People are smart, people can spot that, and that has a bigger effect than the employer might ever know. people aren't going to go to their employer and say, I'm really disgusted by the fact that you've exited that person under a fake redundancy. People just don't do that. But they will speak with their feet. They will find a different employer. They will lose their levels of engagement. So those contrived situations are often very difficult to actually make it work. But also, if you're seeing the bigger picture and if you're valuing people as an asset, then it's not usually the way to go.
And if you're somebody that's been recently made redundant and you question whether it was a genuine redundancy, what would your advice to them be?
I think if you've got questions which remain unanswered, then sometimes you'll be given a right of appeal. You aren't always given a right of appeal. And actually, I tend to say to clients, look, rather than give a right of appeal, get it right the first time. Invest more time in the process. Answer the questions now, as opposed to making a decision and then having to defend it afterwards at an appeal stage. But for someone who's been made redundant, I suppose the things to be looking at are, number one, was there a genuine need to make the reductions? Was there a comprehensive business case for removing your role? Now, that should have been communicated to you, but if you can't see what that is, then it's worth asking those questions. If you were part of a selection pool, was that selection pool probably fairly comprised? Have they left out people who clearly should have been in it, who might have perhaps ended up being made redundant? Have they been too broad or too narrow? So look at that. If they've used selection criteria, are they fair? Are they, slanted against, for example, people who work part-time, which is predominantly women? So are they scoring more for full-time people? Are they putting too much weight on length of service? Are they putting in subjective criteria that can't really be evidenced? You often see things where they get scored for, attitude. So, that's very difficult to, that's hard to quantify. So there's areas of challenge there. Have they exhausted the suitable alternative employment process? Have you seen jobs that were available that you weren't allowed to apply for? All of those things will start to give you a feel for whether you've been targeted. And, that feel is often correct. And if it is, then you can speak to lawyers, you can speak to the Citizens Advice Bureau, or you can escalate it through ACAS potentially to an employment tribunal claim. But I think, it's important to separate the personal distress of losing your job from the analytical side of, was it fair? Now, it may not have been, easy to deal with. In fact, it would have been. Most people have financial commitments. You lose your job, that's a big deal. So it's about trying to separate yourself from the emotional aspect of it and looking at it forensically and objectively. Almost flip it around. If you put yourself in the employer's shoes, do you think what they did stacks up from a business perspective? And if so, then it probably was a fair dismissal. And being a bit heartless doesn't get you a claim, unfortunately. It probably means you might be actually, well rid of the organization. But that in itself is not usually enough. It's got to be, procedural or substantive. Does that make sense?
Yeah, absolutely. So if you're an employer, you've let people go because you lost business, and then a month later you win a fantastic new client, and work suddenly starts ramping up. What are you allowed to recruit? Do you have any other obligations? Can you recruit from the people that you made redundant? You hire them?
Yeah. So the short answer to your question is yes, you can. If the situation's change, you can recruit, you can bring on some more people if you need to. That is absolutely fine. Yeah. But the way to look at it is to step outside and look inwards and think, right, how is this going to be perceived both by the people or the person that we've made redundant, but also by our existing staff who have just seen friends and colleagues lose their jobs, and now, hey, all of a sudden out has come this great contract. And most employers will just sort of bury their head in the sand at this point. And I would recommend like really attacking this head on. I would be saying to your remaining staff, look, I know we made redundancies 6 weeks ago. This new contract has come out of nowhere, which is great for everyone. It means we're going to need to recruit. Like, we want you to know we didn't know anything about this contract at the time that we made the redundancies, or we wouldn't have gone through that process. Like, take ownership of that and like proactively communicate that. It's what your staff are thinking. It's like, wow, look, you've got 3 job adverts now, and so just lost their job. That doesn't look great, Like, communicate this information to them. Like, yes, okay, it requires an element of vulnerability, but that's such an important trait in leadership anyway, in my view, that I think that's a really good thing to do, and it will differentiate you from most employers. Now, if you have done this as a very genuine redundancy, then yeah, you could go back to the people who've made redundant and say, look, we've got some temporary work here. This contract's come in. It's it's only a 9-month contract or something like that. But if you'd like to come back on a fixed term basis to start with, then we'd love to have you back. Now, there's nothing wrong with doing that. Equally, you don't have to. So if, as part of this process, it has proved to be an opportunity to get rid of some people who were perhaps the weakest people in the pool, you aren't obliged to go back and to offer it to them. I mean, they could, in theory, apply for the role if they see it advertised, and yes, they can clearly do the job, so they'd be suitable candidates. You would need to bear that in mind. But at this stage, your duty to prioritise them for suitable alternative employment no longer exists. So if they're not the best candidate at this stage, you wouldn't have to give them the job.
Okay.
But again, like, levels of communication here would be really important, because that's a very difficult message to communicate to someone, to say, look, you used to do this job, but we're not going to take you back because there's someone better out there. That's a difficult message to communicate. And someone might say, well, look, this whole thing was contrived. You knew this contractor was coming in. It was a way to get me out. I'm going to sue you, and then all this has to come out in disclosure, and you've got to spend lots of money on someone like me to defend it. Whereas, like, communicating these things up front generally tends to avoid these disputes arising. And prevention is probably costs you 10% of cure in terms of legal fees. It probably costs you 10 times as much to defend these claims as it would to invest some time and advice to hopefully avoid them through some of these techniques.
Okay. So you can rehire from people that you have made redundant from a tax perspective. I know that people get paid, they don't have to pay tax on their redundancy.
No, they don't. And yeah, so in theory, it would be fine. I mean, if the revenue looked challenged, you'd have to be able to demonstrate it was a genuine situation, and they'd probably want to see your paper trail about how things have changed. I mean, I can't imagine, I haven't come across a scenario where an employer has fabricated a redundancy to get someone out and then to re-employ them. I suppose it would be a way to get tax-free monies to someone. You could make them redundant, artificially pay them monies for a bonus they might have been due, pay it tax-free as redundancy monies in speech marks, and then re-employ them shortly thereafter. I mean, I suspect it might have happened somewhere. I haven't come across anyone doing it before. It's probably, if that's the reason that you're doing it, I suspect it's probably tax evasion.
Yeah, no, do you know, to be fair, I'm sure I'd heard that you couldn't re-employ someone, and then they changed the rules with COVID. But
there are sometimes there are sometimes schemes where if you take voluntary redundancy for a big employer, and I've seen this quite recently actually, where it's sort of, well, look, we'll give you this enhanced redundancy and a settlement agreement, but one of the terms is you can't come and work for us for 12 months.
Okay.
So because some of these organisations with 200,000 employees, you might just apply for a job in a different city or country and get it straight away, and they don't want you back having just paid you redundancy monies. So that happens sometimes, but for smaller businesses, it's quite unusual for that to happen. Generally speaking, the parties will part ways, and that's usually the end of the relationship unless there's a challenge to it. I haven't seen it happen very often that someone comes back immediately, perhaps further down the line, but not usually.
Brilliant. I'm wondering if anyone's got any questions, feel free to ask Tom any comments. The final question I want to ask, because there's been quite a lot in the news recently about non-disclosure agreements and them being included in redundancy packages and settlements. I'm interested to hear your view, and if you're an employer, whether you'd advise an employer to use them or you'd advise somebody to sign one.
Yeah, it's a topical issue, isn't it? And a really interesting one. I can see both sides of it, Liz. I can see that if you're entering into a settlement agreement and you're paying someone, then the employer is paying for the right to not be spoken badly about and for the confidentiality. From a business perspective, I can understand that, and that makes sense. And there's an argument that says you don't have to take the extra money. You still have options to either sue, to go public with it if you want to. So I kind of get that. And in a redundancy context, I think if you're taking a voluntary package and you sign a settlement agreement, fine. I mean, would I recommend using a settlement agreement then? No, probably not, because there's nothing particularly contentious about it. And it suggests that you feel you might have done something wrong. And trying to gag someone about that is, to me, unnecessary. If you've done the process well and they volunteered for it, then they take the money and they leave. The legal risk to you as the employer is low. You should, if you've handled this properly, be parting on reasonably good terms. Why do you need it? I don't think you need it. Broader discussion, maybe one for another conversation, is when you're using them in highly contentious situations. You're paying someone off where they've alleged sexual harassment in work, or you're paying them off because it's alleged that you've discriminated against them because of their disability or something like that, and you're buying their silence for your own reputation. Does that sit well? No, it doesn't. But I can see the purely business perspective of it, which is that you're paying extra money for something, and that something is for it to go away quietly. I suppose in an ideal world, this behavior would always be flushed out and it would just not happen. And in fact, if you remove the sort of gagging element of it, the confidentiality clauses and the non-derogatory statements, etc., you would discourage this behavior from happening if employers knew they didn't have a fallback of just paying people off, of saying, here's $100,000 to go away quietly, which, for someone who's been discriminated against and is about to lose their job, could be a life-changing sum of money. Yeah. It's very difficult, isn't it, to turn down money that will protect your family going forward when you're in an impossible situation. The employer holds all the cards here, and most people will have a price at which they have to take it to protect their own family. Perhaps they're the breadwinner, they might have financial commitments, they might have caring commitments, who knows. So the employer will know this and can leverage it. So in an ideal world, you wouldn't have these NDAs because it would encourage employers to take preventative steps to make sure this behavior didn't happen, but that it would also shine a light on that behavior as well. And it would get rid of the opportunity to just pay people off to hide it. That's not going to fix, like deep-rooted cultural problems in organizations if you can just buy people off. What it therefore requires is someone who's willing to stand up and not take the deal and say, no. This is not about the money for me. This is about highlighting your toxic behavior and culture. Throw whatever you want at this. I'm doing this for a bigger purpose. But it's hard to expect people to do that, isn't it? It's hard to expect people to take on this mantle for everyone else. And you look at people like Jolie Brearley, who are doing it through sort of
Channel 4.
Exactly, and through Pregnant and Screwed and things like that. Like that's someone who's willing to take this mantle on, and that's so important to be able to do it. And if the direction of travel is more towards that, that's a really positive step.
Yeah.
But I think the point for employers should be that you should want to call out this bad behavior, and if it's happening, to own it and say, right, we have zero tolerance for this. This person is not welcome here. We're not hiding behind anything. We're actioning this. Having these in place, to me, says we're not yet ready to take a zero tolerance approach to this behavior.
Yeah, absolutely. I was trying to
massive tangent. This is nothing to do with redundancies.
No, I was chatting to somebody last week about it actually, who runs the non-profit Speak Out Revolution, which is all about sort of speaking out against workplace harassment and bullying, and sort of saying, would it be, maybe it could be a solution to have companies and employers disclose how many non-disclosure agreements people have had to sign alongside a gender
Yeah. It's very early days and quite an important discussion, I think. And I do think there needs to be a balance struck where people are able to maintain an element of confidentiality about their businesses, but I don't know where the line is for that, and how we avoid that creating an environment where people can do what they want if they're willing to pay for it. I am very much, and this is something that Jodie, our founder at Thrive, is very passionate about, is that we want to create the right working environments. Like, our job is not just to protect employers in all circumstances. Now, sometimes that's the brief, but we'd much rather work with clients who want to learn and be better, and say, look, like, we don't want to get in situations where we're having to have this sort of discussion now. Should we do a settlement agreement? How should we deal with this? It's about educating people that this sort of behavior is wrong. That, this sort of bullying, gaslighting, harassing behavior in the workplace, there's no place for it. And if you get people in leadership who take zero tolerance to this sort of stuff, that's how you make change. And that's the kind of big picture goal here, isn't it? Is to get organizations to have the right leadership in place, people who are brave enough to say, this behavior won't happen in our organization, so this becomes an irrelevant question.
Someone's on LinkedIn has said settlement agreements are a useful option to help enhance an exit package, and helpful in that an employee has to take external legal advice.
Yes, it is, but why do you need it? Like, you can pay an enhanced package without a settlement agreement. So the settlement agreement's not the mechanism by which you can benefit from the tax exemption. You can do that anyway if it's genuine. It's an ex gratia payment. Taking the legal advice is a requirement, which is perhaps a good thing if you want to direct someone towards that anyway. But it's not a requirement, and it does sometimes say, like, what do we get in return? Well, all the confidentiality, etc., etc. If you've got confidence in your process and you just want to give someone an enhanced package, why do you need it? There's usually a sort of quid pro quo for it, and that's where you start to get into the realms of, well, why do you even need it? Having another lawyer involved can sometimes be good for the employee, but I can tell you I've had a number of occasions when it's not, because there are unscrupulous lawyers who will say, oh, have you considered an age discrimination angle here? Why don't we say that it's because you're in your 50s, that and see if we can squeeze more money out of them, and I'll do it on a no-win, no fee. And that might have no merits at all, and that doesn't really benefit anyone. That's a contrived claim, potentially being brought to squeeze money out of an employer who might have just been trying to do the right thing. Like, sometimes usually more lawyers is not always a good thing. Now, like, what would be a better approach would be to say, right, well, we've got a redundancy process here. We're willing to allocate, I don't know, £1,000 for you as a group to go and take a bit of advice on this, so that at the start of the process, we want you to know that you've got the support that you need, or perhaps to invest the money in training the staff reps on redundancies and best practice. Yeah. So put the money in early on to say that we want you to feel comfortable with this, to understand how it works. So we're going to cover some costs for you to speak to an HR person or to a lawyer to understand our business case, to get an impartial view, so you feel like you're on as level a playing field as possible. That might be a better investment of the money if you're looking at this slightly more holistically.
Brilliant. So if anyone's got any other questions, I'm sure they can contact you directly. So how can people find you, connect with you, and find out a little bit more about Thrive Law as well?
Yeah, so if you Google Thrive Law, we're pretty easy to find. Our website is showered in teal, which is our sort of primary colour, so you can't miss us. The best place to find me is LinkedIn, really. I'm quite active on LinkedIn. Drop me a message, just connect with me. If you've got any questions or feedback, or if you want to have a rant at me about anything I've said or haven't said, please do. I would love to hear from you. We run quite a lot of events, seminars and things through Thrive Law. We have blogs and things you can find on our website. We're a bit different. I spent 15 years in more traditional private practice at a big firm. And I think what we do is quite special. We bring a much more human element to this from a sort of human strategic perspective and a business strategic perspective, I think, than most firms. And we're values driven. It's all based around Jodie's vision. She's the founder, Jodie Hill. She's definitely worth following on social media as well. She's on TikTok and Instagram and all those sorts of things as well. And we'd just like to hear from you. Just come and see what we're doing, see what you think, and if it aligns with your values, then we would love to work with you.
Brilliant, and that's candidate, employees and employers as well. So.
Yeah, absolutely, absolutely. Our sort of goal is to change the way that businesses operate and how they deal with people, and across all sectors really. And that can be from educating employers, or it can be from supporting employees. And that's the mission. It's a lofty goal, but it gives us purpose to what we do as lawyers, which is sometimes difficult to find.
Yeah, brilliant. Oh, well, thank you so much for your time, Tom. It's been brilliant and so useful. I've learned so much about redundancy today. And thank you to everybody that's watched today as well. Thank you.
Thanks. Have a good day, everyone.
Bye. Bye.